Assalamualaikum warahmatullahi wabarakatuh to Miss Hajar Binti Muhammad Hussein. My name is Siti Fatimah Binti Abdul Kadir and my others group member are Syarafana and Farahani. We are from class KBA 2435A and we are group number 2. Our group assignment title is Issue of Unfair Retrenchment Exercise and Retirement Benefit Claim by Kesatuan Kebangsaan Pekerja Perusahaan Petroleuum dan Kimia Semenanjung Malaysia to TEGO SENDIRIAN BERHAD. So firstly, I'm going to start with the introduction. The industrial code case that we analyse is the trade dispute between Kesatuan Kebangsaan Pekerja Perusahaan Petroleuum dan Kimia Semenanjung Malaysia and TEGO SENDIRIAN BERHAD. TEGO SENDIRIAN BERHAD had put an end to its operation because its operation was mainly relocated to Myanmar and 318 employees were retrenched. It appears that 137 of them are registered under the National Union of Petroleum and Chemical Industry Workers, which is NUPCIW. The retrenched employees decided to bring this matter to the industrial court and they were represented by the union. The case highlights two issues, which are whether the company carried out the retrenchment exercise fairly and whether the retrenched employees are covered under Article 24 of the said collective agreement, regardless they have been covered under Article 25 of the said collective agreement. The act that related to the case are the Industrial Relations Act 1967, such as Section 14 Collective Agreement, Section 20 Representation on Dismissal, Section 56 Non-Complying with Award or Collective Agreement, and so on. Meanwhile, the articles that related to this case are such as Article 24 and Article 25 of the said Collective Agreement, and others Act that related to this case are such as Minimum Retirement Age Act 2012. Next is the legal issue in the case. Regarding the first issue, the company said that the union can argue that the retrenchment exercise was not following the fair industrial practice. This is because from the beginning of the process, the union only claimed that the company did not comply with Article 24 of the said collective agreement in the Form S. Furthermore, the company also paid the retrenchment benefits to the employees under Article 25 of the said collective agreement. According to the triad law, the parties involved are obligated by its pleadings in the industrial jurisprudence. Therefore, the court ruled that the issue of unfair retrenchment is prohibited from being brought up by the union, since it was not pleaded from the start. Next, the second issue argued by the union is non-compliance of Article 24 of the said collective agreement by the company. The union mentioned that the retrenched employee also have the right to the retirement benefit pursuant to Article 24 of the said collective agreement, although the retrenchment benefit has been paid to them. However, the company had their own reason not to pay the retirement benefit to the employees. The company stated that the employees did not fulfill the compulsory requirement to be covered under Article 24 of the said collective agreement. Taking into consideration of both the union and company, it is essential for the court to use Section 56 subsection 2A of the Industrial Relations Act 1967, that is the authority to clarify article of collective agreement in handling the case. To convince the court, the union stated that the employees cannot be terminated unless due to misconduct, breach of the employment contract, or redundancy. If they are terminated not due to those reasons mentioned, the company must pay retrenchment benefit to them. It also was pointed out that the retrenched employees were below 60 years old at that time they were retrenched, causing them cannot retire at 60 years old, as well as to gain the retirement benefits. This is because the retirement age in Malaysia, according to Section 4, Subsection 1 of the Minimum Retirement Age Act 2012 is 60 years old. Yet, the union argued that the employees are eligible to the retirement benefit since they had worked with the company for a considerable length of time and almost to come to the age of retirement. The company will seek to gather and hold the retirement benefits and will be paid to the employees according to their respective share when they are at retirement age. However, there will no such execution done as opposed by the company. The union also refer to the Malaysia Acid Work MAW collective agreement in strengthening its efforts to convince the court. This is due to the fact that MAW Sdn Bhd entitled their employees for retirement benefit in Article 14 of a MAW collective agreement, even there is a slight difference in the formula of calculation between both collective agreement of TEGO Sdn Bhd and MAW Sdn Bhd. The most important part is MAW paid to their employee both termination benefit and also retirement benefit, even the MAW does not have the provision for retrenchment benefits.
Hi, my name is FARAHANI and I will continue with the other legal issues in this case, which is the union argued that when Article 24 of the collective agreement is read together with Article 29, it clearly shows that the retrenched employees are entitled to retirement benefits. According to Article 29G, unbroken year of service for calculating the resignation, termination or retirement benefits will be stated in years and months. According to the company witness, there are no provisions in the said collective agreements which provide that redundancy benefits and retirement benefits are mutually exclusive. The said collective agreements also does not have any provision which state that if the company ceases operation, the employee will not be paid the retirement benefits. On the other side, the company argued that the retrenched employees are not entitled to the retirement benefit as stipulated in Article 24 of the said collective agreement because the employee has to attain the retirement age of 60 years old. Meanwhile, for retrenchment benefit, it will be paid in the event of redundancy termination as provided in Article 25 of the said collective agreement. The company also argued that it is absurd for an employee to claim both benefits because Article 24 and 25 of the said collective agreements are mutually exclusive. Mutually exclusive means an employee only entitled to one of the two benefits provided in the collective agreement. If this employee were entitled to retirement benefits, they will not be entitled to redundancy termination benefits and vice versa. Now, let us continue with the legal issue that is related with class lesson. The legal issue that has been identified in the case can be seen related to the collective agreement under Chapter 7. Under Section 14 of Industrial Relations Act 1967, collective agreement is a written agreement between two parties concerning the terms and conditions of employment. Basically, there are two collective agreements pointed out in the case that is the said collective agreement and Malaysian Acid Work Collective Agreement. The parties to the said collective agreement was between Kesatuan Kebangsaan Pekerja Perusahaan Petroleuum dan KIMIA Semenanjung Malaysia, which is the trade unions of employees, and TEGO Sendirian BERHAD, which is the employer. Another legal issue that is related is trade dispute under Chapter 8. According to Section 2 of the Industrial Relations Act 1967, trade dispute means any dispute between an employer and his workmen which is connected with the employment or non-employment of the term of employment or the condition of work of such workmen. The trade dispute between Kesatuan Kebangsaan Pekerja Petroleuum dan KIMIA Semenanjung Malaysia and TEGO Sdn Bhd is caused by the non-implementation of an agreement by the employer. The employees were unsatisfied with the decision of the company to retrench them, so they decided to complain this matter to the industrial court, and the retrenched employees were represented by the union. Apart from that, the legal issues that have been analysed in the case can be seen related to the court and claims relating to retrenchment under jurisdiction of the court in Chapter 10. According to the list of possible reasons for retrenchment from the Department of Labour, closure and part of operations shifted to another place are the two reasons similarly indicated in the case. The company retrenched all the employees as it ended its operation and relocated to Myanmar. As explained in Chapter 7, retrenchment is under managerial prerogative, so it is not a bargainable matter.
Greetings to everyone. My name is Syarafana Binti Salehuddin, and I will proceed to the next legal issues related to class lesson or discussion. The next legal issues related to class lesson or discussion is under Chapter 10, that is managerial prerogatives. Under Section 13, Subsection 3 of the Industrial Relations Act 1967, stated that the employer has the right to terminate the services of employees for reasons of redundancy or by reasons of reorganization. In this case, the company terminated its operation and made a decision to relocate to Myanmar and caused a total of 318 employees to be retrenched. Basically, the role of the court is to ensure the company done its retrenchment exercise fairly. The case also can be related to Chapter 10 under interpretation of collective agreements or awards. The court is responsible for interpreting the meaning of any part of the collective agreement or award that can be disputed by the parties involved. Trade unions and employers may be convinced that they both agree on the meaning of a particular clause or part, but there is time when both parties do not agree on what should be the correct interpretation. In this case, the union applied for an interpretation of two clauses, that is, whether retrenchment exercise was carried out according to fair industrial practices and whether the retrenched employees are entitled to retirement benefits. The court decided that the first issues cannot arise as it was not pleaded, while for the second issues, the court decided that the company did not breach Article 24 of the said collective agreement and the company did not have to pay the retirement benefits to the retrenched employees. The last one is related to Chapter 10, that is complaints of non-compliance. Under Section 56, Subsection 1 of the Industrial Relations Act 1967, complaints can be made to the court in written form by a trade union or person that is obligated under collective agreement if there is any matter regarding to the collective agreement that has not been complied. In this case, the union claimed that the company did not comply with Article 24, which is retirement benefits, and Article 25, which is retrenchment benefits of the said collective agreement. Thus, the union has the right to make a writing complaint to the court. Next, we proceed to the recommendations. There are some recommendations that we would like to suggest after analyzing the case. To begin with, the union mentioned that there was an unfair retrenchment exercise. However, it cannot be argued to the court since it was not pleaded at the first place and it was not even stated in the union's statement of case. Thus, the union should be more aware and recheck carefully if all the issues are stated thoroughly before filing the complaint to the court. Next recommendation is that the union ought to understand properly and take seriously whether every single article in the collective agreement discussed is appropriate or not to the employees during the process of creating the collective agreement. Hence, no issue will be arise or argued when the collective agreement is implemented. Other than that, regarding the issue of unfair retrenchment exercised by the company, the court decided that the issue is not relevant to be argued as it was not pleaded by the union. Nevertheless, the company should implement code of conduct for industrial harmony, such as giving early warnings to the employees involved and providing voluntary separation scheme (VSS) to them. Not only that, the company can at least practice good management and industrial relations by assisting the employees with secretarial services and access to computers and internet for them to find new jobs. This can help to lessen the burden of retrenched employees. To conclude, the case that we have analysed is about a trade dispute between Kesatuan Kebangsaan Pekerja Perusahaan Petroleuum dan KIMIA Semenanjung Malaysia and TEGO Sendirian BERHAD. The two issues of the case were solved properly with reference to the jurisdiction of the court, where for the first issue of unfair retrenchment exercise, the court decided that it cannot be brought up since it was not pleaded in a written form, while for the second issue of whether the employees were eligible to the retirement benefits under Article 24 of the said collective agreement, the court decided that the employees were not eligible to the retirement benefits and the company did not have to pay them the retirement benefits since they had received the retrenchment benefits under Article 25 of the said collective agreement. This is because those benefits are mutually exclusive. The case has shown us that there are many statutory laws, sections, and articles related to one another. In describing each argument by both the union and company, in fact, the key points in the case are significantly linked to the theories that we have learned through books during classes. Therefore, it cannot be denied that it is crucial for students like us to stay focused and keep on learning as much as we can. This is due to the fact that we might experience this kind of similar situation, as well as we have the knowledge on how to handle it when we are in the realm of employment in the future. So that's all from us.